Welcome to Encura's Navigating Change Conversation series. Today's conversation is the new administration challenges, next steps. I'm Kathleen Larmet, Encura's Executive Director, and with me today are Ted Waters, Managing Partner at Feldesman Leifer. Ted has served as Managing Partner of the firm since 2003 and is a member of the Healthcare and Federal Grants Practices since 1992. Ted is a national authority in the area of federal grants, particularly in the health and community services spheres. He serves as an adjunct professor at the George Washington University Law School and is a past board chair of the National Grants Management Association. Joining Ted is Mindy Pava, a partner at Feldesman. Mindy serves as a partner in the firm's litigation and government investigations, federal grants, healthcare and education practice groups, where she focuses her practice on advising federal grantees, including research institutions and health centers, as they navigate all facets of administrative and judicial review. And today's moderator is Dennis Paffrath Nelson, Associate Vice President for Research in the Office of the Vice President for Research at Temple University, where he has oversight of the Office of Sponsored Programs Administration. He also works with the university's various schools to create and maintain a well-developed process for all research administration. Welcome, everyone. And now I'm going to turn this over to Dennis.
Good afternoon. Welcome for everybody to join us during this presentation. As Kathleen stated, I'm the moderator. And first, this is being recorded, just so that you'll know, and it'll be available at a further date. During the presentation with Ted and Mindy, please, if you have any questions, please use the Q&A box located at the bottom of the screen. We will try to get to as many questions as we possibly can, and hopefully we'll get to quite a few of them. So welcome again, and now I'm going to turn it over to Ted.
Dennis. I think Kathleen's already given us an introduction, so the main thing here is our email address. And if you have any questions after today, feel free to email us. But Mindy, turning to you.
Sure. Hi, everyone. Mindy Pava. Just quickly, as I said, Ted and I are very grateful to be here. I want to thank Kathleen and the whole team for inviting us to speak today. Just quickly, if you've been to any of our other trainings that we do at our firm, Feldesman Leifer, we do have to do a quick legal disclaimer that says this is general advice about the world of federal grants and how it's being applied to you now as research institutions. This is not specific legal advice. Don't say, well, the man and the woman on the webinar said to do it this way, so I'm going to do it this way. If you have a specific factual concern, please let us know individually, but hopefully this is a nice general broad overview about all of the different areas and chaotic times that we are all experiencing. We also have a copyright right here, just saying that again, this is attorney work product. Please, if you're joining today, use it internally within your organizations, but don't post it as your own on social media. That's basically all that needs to be said about that slide. And next, our agenda. I can go over this quickly, or Ted, you can weigh in too, and then we can get started to the meat of our presentation. We obviously have a lot to cover today in only an hour. We could probably talk for several hours about all of these different areas in the changing landscape of federal grants as it's being applied to research institutions. But first, grant terminations. Obviously, most of you on this call are familiar with those, and we're happy to walk through, the guidance that we're giving to our clients who have come to us seeking help in this area. Indirect cost rates, we're seeing that obviously NIH, NSF, and Department of Energy. What is happening with these proposed caps? Obviously, there's ongoing litigation for all three of these agencies that are trying to impose these new indirect cost rates. So what is happening in the courts, and what do we advise you should do if you're needing to submit a new rate now? Federal court jurisdiction, if you are disputing anything relating to your grant, should you be going to district courts or should you be going to the Court of Federal Claims? We'll cover that. the new world of DEI certifications, especially in the HHS, GPS, and the NIH notice that was put out about this. Your grant terms and conditions are now starting to include these DEI certifications. So what does that mean for you? Of course, NIH Foreign Subaward notice that was issued at the beginning of May. And then the world of PMS and ASAP drawdown justifications. Getting your money has proven to be somewhat more challenging in this new world that we're in. And of course, as Dennis said, we want to leave some time for Q&A. So Ted, unless you have anything to add about any of these categories or any overview, or Dennis, feel free as well. We will get started. Hearing none. Okay. Grant terminations. Ted and I will both speak to this. Obviously, many of you on this call have gotten those letters through your Office of General Counsel or maybe sent directly to your research office. And the terminations, we've seen them come in large buckets from NIH, NSF, Department of Education, EPA, Department of Justice, National Endowment for the Humanities, Department of State, the list goes on and on. And the issues that we're hearing are, okay, are the terminations over? We received X number from the NIH in early March. Should we think that any grant that was not terminated in early March, that's an NIH grant, is that over? Unfortunately, the answer to that is we can't be sure. Like you, we've seen those large buckets of terminations come out from different agencies at different times, but we've also seen trickles. For example, there were many NSF terminations that came out mid-April. 30 days if you're appealing are now due mid-May, but then we saw a few others come out just 2 weeks ago. So, I think there's been to say, okay, the NIH is done or the NSF is done or Department of Ed is done. We wish we could give that advice. Probably not accurate to give that advice. So you get the termination letter from your agency, from your funder. What are the next steps? You can choose to challenge that termination. Some of the termination notices give you 30 days to submit an appeal within the agency process. Some recent termination letters, NSF, for example, are saying this is a final agency action. There is no appeal. There are, however, procedures under the PAPG and other administrative guidance that does allow for appeals. So we do know of some institutions that are saying, even though the letter says there's no appeal, we're still going to go by normal agency process and procedures and submit an appeal because we want to reserve our rights. There's also the issue of submitting an appeal, even perhaps with a low chance of success, but just to show your PIs that as an institution, you support them, you support the research you're doing, and you want to have something on file that shows that you're disputing the action the agency has taken. Some arguments to make in these appeal letters, if you choose to appeal, are that these were broad across the board terminations. There was no individualized look at your individual grant and what that grant stands for. Certainly, things that like the uniform guidance says that in certain instances, the no longer effectuates agency priorities language. Is that an allowable rationale for a termination under the uniform guidance? There's different things that say there's different scopes on that, but those again are some arguments you can make. And then also looking at the grant, the scope of your project, and saying maybe some of it touches on a word that has come up on a keyword search, but that is not really the heart of our project. The heart of our project has nothing to do with anything that is now outside the agency, the administration's new priorities. Agency, we think you're misinterpreting the scope of this grant. So those are some of the arguments that we have helped our clients make on appeals. Obviously, it's up to each institution whether they want to appeal a grant termination, whether they think that's the right move on behalf of their institution and on behalf of their PIs. We certainly think that there's some value in it, but we're also seeing agencies now in the grant termination letters expressly disclaim that there even is an appeal right. So that's an interesting development to watch moving forward. Ted or Dennis, I don't know if you also want to weigh in on this issue.
Couple of things. First, the justification for these terminations is usually that there is the language in 200-340, which says this doesn't effectuate the government's priorities anymore, this grant. That language is not currently in Part 75, which applies to HHS grants. So that's one legal flaw. All these terminations are of questionable legality, but that leads us, well, when we talk about jurisdiction, to not a good place currently, which is it's questionable whether we can get these blanket terminations enjoined, as opposed to having to go for cost or restitution or damages. And the last bullet here, allowable cost. You do have some in Avenue, which is 200-472 termination costs. It's also important to know when the uniform guidance was changed last year that closeout costs after the period of performance can now be claimed as well. Having said all that, getting your termination costs, including legal fees and consulting fees, paid back is kind of, to me, cold comfort because, of course, federal grants, you have to pay the money out. And then you're saying federal government, severance pay, for example, lease terminations, now pay me back government, and that may be an extended process. And the last thing I'll say, and it's unfortunate, we keep talking to really lots and lots of groups of folks, and I wish we had great news, but none of this stuff, and this is really kind of a theme here. These issues, I've done grants for 30 plus years, and these are all new issues. If you were a federal contractor, this basically the equivalent is termination for convenience. In the federal acquisition regulation, there is a very well established process and kind of standard operating procedure. What can you recover? What can you not recover? You don't get a lot of pushback, provided you can support what you're claiming. And this is all new ground for grants, which means that it's nobody is sure. It's the wild, wild west. And but I think what Mindy said earlier, you got to try. Whether there is success, I would not completely count on the litigation avenue, at least the broad litigation cases, given some of the stuff we're going to talk about in a minute. But keeping your foot in the game, and on the terminations. Much of it may well be a waste of time, maybe not. Nobody knows again. But we have had some clients with success if you can come up with a rationale that will appeal to the administration about why this grant should be restored. So, all right.
Okay, so a couple of questions I'll ask. The first one, it kind of goes with what created a lot of the terminations. We feel that seem to be, a massive keyword search, and boom, your grant is terminated depending on how many keywords you had within your grant proposal. There's a question about maybe going forward, some suggestions about when you know that you have principal investigators or key personnel biographical sketches that have some of these trigger words, what would you recommend they do?
Well, Dennis, that was our DEI slides, but
Oh, okay. So I apologize. We can.
but it's a great question, and as lawyers, it to me is gut wrenching when what we're saying is you have to decide as an institution, do you want to undermine your rights to free speech, frankly, which is, do you not use these words because the US government said don't use these words? That to me, and there is case law in the Supreme Court on First Amendment issues and federal grants. One of the most prominent ones had to do with USAID, but if you want to go along to get along, then somebody was asking me, well, the job title that was rejected was Chief Diversity Officer. So do you change, if you say change it to Chief Engagement Officer, then it's fine. And that's kind of how silly this is if you chief engagement, good, chief diversity, not good. So, but it's up to each institution to decide. But I don't know.
So,
I mean, yeah.
I would also just add to that that there's going to be certain words that we know that get caught up in a keyword search, but maybe in the narrative and your scope of project, you just underscore the fact that whatever project you're doing, whatever study the research is looking at, it's open to all, even if the research maybe seems geared towards one type of protected group, that anyone can sit in on the program, anyone can sit on the class, the survey can be taken by everyone, and then maybe you still get flagged for the keyword, but in whatever you're appealing, you can say in the scope of my narrative, I also wrote that this was not doing anything that should run afoul of anti-discrimination laws or preferential treatment, just to really underscore in whatever opportunity you can that there's no group classifications going on here and that the project is open to all, if it is in fact open to all, and just trying to really get at that type of being proactive, being assertive in the way that you're writing your scope of project narrative, so that if you get that blowback on the back end, you have a leg to stand on.
So just a quick question, you maybe just
Yeah.
yes or no. Is there any place or area within either yours or that you're aware of that there's an ability to find sample appeal letters of terminated grants, just to have some idea of how they're being composed?
So I've seen
Um,
some.
Go ahead, Misty.
No, I was just gonna say I've seen some associations that have done that, and I know in some instances, if you're part of certain groups and there's listservs, I know Yale, for example, had circulated some for the NIH, I believe. So there are resources out there. I think, in some of the ones I've seen, those letters are giving a lot of leeway to the PI to write how great the grant is and how important the purpose of the grant is. And obviously the PI really most of course believes that in his or her heart of hearts. I think the best tack with these approach with these appeal letters is to really go after the law and why the no longer effectuates agency priority language is not appropriate here, why the grant itself, still falls into priorities that might be allowable under statutory authority. We've used a process where if the PI has wanted to attest to how wonderful the grant is, we've supplemented with a declaration to an appeal letter, but having pages and pages in the appeal letter just attesting to how great scientific advances are being made in the grant is probably not going to move the agency the way that a comprehensive legal argument would.
Yeah. I mean, the bad news is this is a legal process and you need a lawyer and a template. We've had that request many times, and it's not the structure of the appeal letter, it is the content, the law, and the facts in a understandable and clear way.
So yeah, and I'll just add that from our perspective at a university at Temple, it's legal counsel who helps draft the appeal letter. We do add, certain sections in there to make, to about the science and why it's not just about whatever the topic is, that it is more encompassing than what they've determined it to be. And then kind of moving on to that, has there been any place or anywhere we've seen where anybody has gotten a successful appeal?
I have heard I've heard rumor to that effect, but Mindy, I don't think we have a number and a large number that are pending.
Yeah.
I mean, talking about now, I mean, been in done disputes with the federal government for a very long time, and of course,
So
we're also
we've heard in a few instances where if you've proposed a very, very slight modification, that the agency may interface with you, negotiate with you, and that's again taking out a few words or taking out one small aim that might be the small aim that no longer effectuates the agency's priorities. Again, we'll get to that more on the DEI slide, right?
Right.
So we've heard about possibly that, but I think some of this is too new. I mean, some of the terminations just came out in March and then were you have 30 days. So the appeal letters just went in April. We're only on May 15th now. I think we're a little Pollyanna to think that our government, especially in today's day and age, is moving that quickly where there's a firm decision already. So we'll see. Again, as Ted said, this is a whole new ball game. There's not a lot of precedent. We can't even advise how long the agencies are going to take. They could sit on these for several months, if not longer than that. So there's not a lot of precedent, but we are still submitting these appeals. The NSF deadline for the biggest bucket of NSF appeals that came in mid-April, I think, is due end of this week, early next week. So some of them are not even due yet. So it's hard to answer whether there's been success.
I think the other problem with the grants law and due process rights and grants, if you were a contractor, there's something called the Contract Disputes Act, and the government has 60 days to move on your request for a final decision. And if they don't, then it's deemed denied, and you can then go to court or go to what's called the Board of Contract Appeals. And the reason it has that 60 days is what unfortunately we're facing on the grant side, which is the government can sit on this stuff for a very long time. At some point, you can say this is ridiculous and go to court, but there isn't that clear timeline. And so, so it's just another part that hopefully there'll be some legislative fixes someday as we all get through this. But anyway.
Okay. So I guess we can move on to the next agenda topic. That's most of the questions that were asked for this section.
Okay. All right. So indirect cost rates. I flew back from California last night, spent most of the time on the plane on this subject about what do we do. So national NSF funding. We had one client. We got to submit a grant application for a large NSF grant. It was last night. And what you have is NIH, Department of Energy, NSF, all have issued guidance saying we're capping your indirect at 15%, kind of borrowing the de minimis rate, really. And as we have on this slide, NIH didn't even identify what the allocation base was as opposed to the standard kind of modified total direct cost, which is not a great allocation base. The justification as it has here, 414C, hasn't really been followed, which is you can have class deviations if the federal agency explains the criteria they're following. And by the way, cutting costs is not a criteria. In fact, to me, that raises, frankly, federal appropriation law issues that all these things do. But NSF, the NIH, Department of Energy, and we'll get into how stable are these injunctions. NSF, there is a lawsuit, but there has not been a motion for a preliminary injunction yet, or some sort of, kind of a, there's TROs and preliminary injunctions are emergency relief. So NSF is kind of front and center. If we go to the next slide, the issues, by the way, that everybody's struggling with is, all right, I have this grant application. Do I do what they say, put 15% in the indirect cost line of the budget? And one suggestion is to put in the comments a note that you're preserving your rights. And And the other is to put your full blown negotiated indirect cost rate agreement rate, your F&A rate, into the application. Choice one, the 15%, I can tell you, I don't think as a legal matter, the note is going to preserve much of anything. The other thing about grants is once you get the grant award, which you probably, have the best chance of getting the award if you put in the 15%. But, once you draw down the first dollar, of the grant award, you've agreed to the terms and conditions. So I think once you draw down the first dollar, you've probably wiped out your reservation of rights. So that's an issue. The other esse, frankly, as somebody who spent much of my life in cost principles, last night on the plane, I was looking for the FAQs for the uniform guidance that made very clear you don't even have to have an indirect cost rate. You can just direct charge everything. Those kind of structural changes, especially for large institutions, which, if you knew these were the rules and you had a year or so to figure it all out, you potentially could live within this 15% or have no indirect and still recover all your costs. But of course, when they do this, I believe the NSF guidance came out on May 3rd, and it's effective 2 days later. Very hard to turn around the Titanic, so to speak. But so 15%, you can try to strategically figure out how to increase your direct cost in some way. 15%, what does that cover? The uniform guidance doesn't really tell you what's an indirect cost either. So choice one, 15%, you're probably not going to cover all your costs for that particular grant, but maybe that's good enough for now. Other choice, put in the negotiated indirect cost rate agreement in the application, and then in normal grant world, if you put in the wrong rate or yet there were questions, the government, NSF or NIH or whoever would come back and say, hey, you have to revise your budget. You don't get completely kicked out, deny, your award or chance of an award doesn't get completely denied. There's a back and forth with the government. We've heard rumors that that's still the case, but I don't know because, in my opinion, putting the full rate in is probably the best interim strategy, but there is a risk that you will just lose out completely. The reason I say it's probably the best strategy is you're putting a placeholder into your application, even if they reject, unlike the kind of the note in the comments, you said we are owed our rate, whatever it is, 55% or whatever it is. And now you're saying you're not going to pay that. We're going to proceed based on what you told us, but that preserves your rights probably to go to the Court of Federal Claims should you want to spend lots of time litigating this stuff and try to recover the full rate, because what is also very clear, and the reason these injunctions have been successful to date, is that none of this stuff is consistent with the uniform guidance. And not just the uniform guidance, you have an indirect cost rate agreement between you and the federal government that says these rates are supposed to be used. You also, for larger institutions, have disclosure statements under the cost accounting standards that you're supposed to be consistent. I mean, there's a whole body of law that is being ignored in all this, and it's a real problem. It puts institutions in a heck of a quandary. But I wish I could tell you best path, use your negotiated rate, use your 15%. There's a clear sailing, and I can't tell you that. So.
So this one has driven, I think, quite a few more questions with regard to the
Yes.
Department of Energy, which seemed you came out with their ruling, then a TRO was put in place, and they put out new guidance with regard to it. So a question came in to say that it seems that Department of Energy has stated that whatever your IDC rate is, it doesn't matter. The Department of Energy has a cap of their reimbursement for indirect costs totaling 15% of total award. They're just wondering how you would interpret it and provide general information on how to proceed, given that new wording.
Well, again, you ask a lawyer, to me, the first thing is what are the rules? And there are grant programs with administrative cost caps, and there are plenty of grant programs with other cost limitations or instances where Congress has modified the uniform guidance, for example. But that's because Congress did it. And so my first thing, again, cold comfort, but I don't think putting a cap is lawful because you are undermining the will of Congress, and it is Congress that has the authority under the Constitution, under what's called the spending clause, to create grant programs in the first place. And if Congress said there should be 100% reimbursement of the cost of running this program, then that's the rule. And so saying we're going to put this cap of 15%, I think is just unlawful in the first place. Having said that, again, to go along to get along, DOE says we're only paying 15%. I mean, in the programs we work in where there are caps, the fact is those costs don't go away. And so you're basically, until you change your cost accounting practices, you have to eat the cost, basically. The difference between your 15% and your whatever 50%, that's got to be paid out of general funds or something. And so that's, so the question is it and frankly, it's, and all these questions is like, how much are we going to take again to go along to get along, and how much, at what point is it untenable?
If
So
you're
then a question. Go ahead.
sorry,
Sorry.
no, just one other aside to that. If there is a TRO or a preliminary injunction in place, and it seems like the agency is possibly doing something that violates that, you can contact the lawyers that have brought that case, the lawyers on behalf of the association that's brought that case, and direct that to the lawyer's attention, and they can go before the court and present that in the form of a declaration or an exhibit, to a court filing saying, Your Honor, the agency, there's a TRO in place blocking the agency from doing this. They're saying too bad, and that could possibly lead to more judicial relief. So, I mean, if it's in, this seems like it might not be, but if there is a TRO or an injunction in place and the agency is expressly doing something that violates that, a court is not going to take that line down if it's brought to the court's attention.
So kind of a clarifying question for you, Ted. Specifically, you had mentioned that maybe you should include your indirect cost rate agreement in the application. They're just wondering where. Would you include it in, say, like the budget justification, or would you just reference to say you really need to go look at our indirect cost rate, which is at the Federal Clearinghouse?
Perhaps I misspoke. I mean, there's a
Okay.
line in the budget that says, what's your indirect cost rate? So in your budget application, you don't typically, in fact, your negotiated rate agreement is pretty much a public document, but you put the percentage in there. I think the advantage, frankly, again, Department of Energy is saying you can put whatever you want. We're going to cap it at 15%. At least then potentially preserves your rights to go to the Court of Federal Claims and get damages payments again down the road. And again, how much are we talking is kind of a big piece of any litigation. But
So the last question for this section, it
sure.
really revolves around do any of your clients or anybody you're aware of are complying with the 15% rate to increase the odds of getting an award? And if so, what are the implications for those fighting to maintain their negotiated rate?
Well, I don't think we all have to do the same thing. So you don't waive rights because somebody else um, decided to put up the white flag and take the 15%. Um, I talked with one of our clients last night, or I was on the plane, so we couldn't talk. We were trading emails, like which path should we go? They decided to do the full indirect and preserve. I think that's the best way to preserve rights. But if you do the 15%, again, you get the funding, and I think that doesn't mean the indirect costs go away. So you've got to cover those costs. Otherwise, and a fundamental piece of cost accounting is consistency. So when you have these large institutions also get federal contracts or do have these cash disclosure statements, you're telling the government you're consistent in your treatment. So if you have 15%, those costs don't go away. You can't shift cost or charge it to other funding sources. You have to pay it yourself, basically. So I think and that's also raises concerns, especially for smaller institutions, like where's the money coming from? So,
Okay.
all right. Well, I know there's lots more, Dennis. I don't know.
Oh, there's a lot more questions, but I think they'll go into this next session. I didn't want to, jumpstart
Sure.
that. So
Sure. So the last piece of why I keep mentioning this Court of Federal Claims, and just really quick, because we have now talked about this and put many clients to sleep on these jurisdictional issues. But the question up until 3 months ago, if you'd said, well, we have this grant dispute and the government is violating the statute, the regulations, the Constitution, the uniform guidance, where do you go? I would have told you there's a Supreme Court case, Massachusetts versus Bowen, go to federal district court. And the Supreme Court, and unfortunately, these are these what do they call it, the secret docket or whatever it's called. They aren't even fully formed decisions. They aren't briefed 6 ways to Sunday and had oral argument and everything, like what you heard about birthright citizenship today at the arguments of the court, which also actually was more procedural than substantive. But based on all indications, there seems to be a strong trend, which is grants are really just contracts with the federal government, contracts with no profit. And since as contracts, a dispute over that contract goes not to federal district court, and I think I already mentioned where you have injunctive authority, which is you can say, stop, make the award. You go to Court of Federal Claims and say, our Department of Energy example, my rate is 50, 60%. You paid me 15%. You owe me the difference. That is a Court of Federal Claims case, which is you owe me the difference. It takes a couple of years, and then you would get, if you're successful. I mean, there are some advantages to the Court of Federal Claims that they don't have the kind of deference to the federal government that you would get federal district court. But the reality is, and I assume everybody on the phone or the Zoom would agree with me, the reality is we don't want damages. We want our grant awards, and we want them to follow the rules. And that is kind of the now holy grail here, which is we just want them to follow the rules. And what court to go to is not clear. And when do you go to one court and when do you go to the other? The more it's just a blanket violation across whole industries or programs, the more I think you're being federal court as opposed to your individual, like these appeals probably are stuck in Court of Federal Claims. So
We are seeing some federal district courts that, after the Supreme Court's opinion in Department of Ed versus California, that steered these types of cases to the Court of Federal Claims, we are seeing some federal district courts that are now facing, grant termination cases or other issues with grants. We're seeing, I'd say, kind of a split where some of the federal district courts are saying, jurisdiction is wrong here based on the Supreme Court's recent decision. Court of Federal Claims is the right jurisdiction. But then you're seeing others that say, well, actually, a grant is different than a contract, and the Supreme Court decision was on the emergency docket. There wasn't full briefing, there wasn't full argument. We don't think that, basically, which district courts are not supposed to do. They're supposed to take what the Supreme Court said and use that as precedent, but you are seeing a few district courts say, hey, I think we still do have jurisdiction over these grant cases because the case has been brought to us because the plaintiff is challenging the policy of the government's decision to terminate the grant, the government's decision to impose an indirect cost rate. So it's not just saying, hey, we want our grant funding back. It's challenging this programmatic and policy larger decision. And that is something that potentially a federal district court still has jurisdiction over. So some of this is coming down to a very nuanced legal argument about what is the plaintiff actually arguing in the case, what is the plaintiff actually seeking, and honestly, if you have a federal district court judge that is going to go against this very short and unreasoned opinion that the Supreme Court pushed down in Department of Ed versus California.
I will say, last thing I'll say on this, the NIH indirect cost memo that has now been enjoined, to me, that's kind of going to be the test case, because on the one hand, it affects each of you individually, and therefore you'd say if it was, again, grants or contracts, and therefore you should be in Court of Federal Claims, but it was a across the board government action. And so on the one hand, the implications are to the individual institutions, but on the other hand, normally that across the board action would be clearly in federal district court. Hopefully that's where things will stay, but I think that's going to have to go to the Supreme Court too.
So kind of outside of the federal court jurisdiction, but some questions about, the lawsuits itself. Wondering, the NIH and DOE seemed to go into the court pretty quickly, and a TRO was the thing. What seems to be different about the NSF court case?
So we're not the lawyers, but if Mindy, you know what the strategy was there.
So I believe that it was an issue of direct harm, like immediate irreparable harm. I believe, and correct me if I'm wrong, Ted, but that the NIH case and the DOE case, they filed a TRO immediately because the new rate was going to be imposed like the next day, even on all existing grants. So it was, even if you had a grant that the budget year was supposed to last all the way until September 30th, your indirect cost rate would have been changed in the middle of that existing grant. The NSF notice, I believe, was slightly different in that it imposed the indirect cap of 15% on any new grants, but not on existing grants. So the issue there is, can you prove irreparable harm, which is needed for a TRO? So kind of a nuanced legal argument, but I think the lawyers probably, and again, we're not the lawyers, but I think the lawyers noticed the difference between applying it to current ongoing existing grants versus new grants and said, we're going to have a harder time filing a TRO today. And sometimes that happens. You file a complaint and a TRO together. In this case, it's looking for a preliminary injunction to enjoin that as a longer term process, but not seeking a TRO because of that issue of where's the immediate harm.
So understanding that, some of the other lawsuits that I've put forward, is there any time frame in your mindset or approximation when these things will be settled, if ever?
We'd be really good litigators, Ted, wouldn't we, if we could tell everyone when a court would rule on a certain
There you
thing,
go. You'd
right?
be hired by everybody.
I mean, the normal process, we file fair number of these, not long before this, these preliminary injunctions. The idea of TROs and preliminary injunctions is judge, as Mindy said, there's irreparable injury. And you also have to show you're probably gonna win your case, and you gotta stop the train right now because it's about to run me over. And then now we stop the train, then the regular case continues. And that usually in federal district court is a couple of years, depending on, the lawyers and the judge and everything else. But these both TROs and preliminary injunctions are emergency relief to again stop the train. And so once you stop the train, often then you aren't nearly as worried and you can go on to normal, or you actually say, well, convert it to what's called summary judgment, and then the judge says you win, and then they can appeal. They can also appeal preliminary injunctions. But anyway, it's the answer, I think Mindy correctly said, is no idea. But guessing about 3.5 years from now, we'll be done with this.
We've had very easy motions pending before courts that we thought a court could rule on within a few days that had taken months, and we've had very complicated motions before courts that we said, gosh, it's going to be several months, and it's only been a few weeks. So it depends on the judge. I will say that, as Ted said, getting a preliminary injunction, getting a TRO could be only a week or 10 days after a filing, and then getting a preliminary injunction could be perhaps a month to 5 weeks after a filing. However, now you're seeing a situation where if you are successful in getting a preliminary injunction, the government is appealing. So you'd appeal from a district court to the Circuit Court of Appeals, and then it's a whole nother briefing process. So from your all's perspective, I think the key is to know that this is all in flux in the courts, especially with the overarching jurisdiction question on should we even be in district court that Ted just briefed us all on. So relying on, okay, well, my grant is back up and running because there's a a preliminary injunction right now blocking the termination. That could very well change due to a circuit court, court of appeal decision, due to, an on the merits decision. So everything right now, it's great if your grant gets reinstated due to a PI, but I think everything needs to be viewed as somewhat in flux for the next few months at least, and possibly for another year or so as all these challenges wind their way through the court system.
So since we
Last
have
thing
about
is-
10 minutes left, I don't know if we want to move on because we do have a
Yeah.
couple of more topics. Specifically, I think we've gotten a lot of questions on the NIH subaward, so we might want to move to that
Sure.
one more so than the DEI certifications. You might want to talk a little bit about that, but then move to the NIH for federal
we
foreign
kind of
funding.
hit DEI already, so I think
Right.
given the shortness of time, but I do, and I'm sorry, Dennis, the last thing I'll say about the last topic, courts are blunt instruments. The one body that could do something is Congress, and that's going to be potentially quicker relief than courts. So, okay, so why don't we move on to subawards?
All right, the NIH foreign subawards, as Dennis said, potentially the question of the hour. So as you all saw, it was about 10 days ago, the NIH announced they're establishing a new award structure that will prohibit foreign subawards from being nested, their word, under the parent grant. And this change applies prospectively to all NIH grants and cooperative agreements to domestic and foreign entities for new, renewal, or non-competing continuation awards. I believe the notice date was May 1st, somewhere around the start of May. So basically, after that date, the NIH is effectively saying it's not going to approve any new foreign subawards or additions to ongoing projects. The NIH wrote in the notice that by September 30th, 2025, it's going to be implementing a new award mechanism for foreign collaborations. More information to come, but right now it looks like we're in this no man's land, I guess, from May until September 30th, unless it's announced sooner, where what happens to these foreign subawards as the NIH is trying to figure out its new policy. So there's a few questions we've heard from the field, the language that the NIH will not issue awards to domestic or foreign entities that include a subaward to a foreign entity. When the policy states, that word will not issue awards, is that, just referring to the issuance of new notices of award or the issuances of payments for current award reimbursement? So say you're in the final year of a grant, and that grant you have a foreign subrecipient, and the NOAA was issued, a year ago prior to this May 1st notice date. Are you able to continue to collaborate with them and to pay that invoice through the project's end date? And I think our advice right now on that is yes, you can for an existing award, because the notice states that the NIH will not retroactively revise ongoing awards to remove foreign subawards at this time. So I think the issue is you can still pay on your current awards, but the issue is just, new awards, not issuing awards. Those are new NOAAs, is the way I read that, at least. So, currently awarded grants, we think you can move forward with the foreign subs, but understand that the structure may totally change in September, and it might affect existing NOAAs, existing awards as well. And then the question, okay, so what if you're submitting a current proposal right now? What do? You're after that May 1st date. So presumably this new interim no man's land structure is in place. What if you're submitting your grant proposal now? And I think the interpretation there is, unfortunately, you're somewhat out of luck that after the notice date, the foreign subawards will be rejected during this interim period, and the NIH is not going to be considering a foreign component until this new process, whatever it may be, is issued and initiated, in September. So I think right now it's a tricky time, but I do think the language is such that you can believe that current existing awards with a foreign component to them, a foreign subaward to them, you can continue to collaborate and pay the invoices on that award.
So, there's quite a few comments. One is, I know that I'm going through my own problem with a subaward during just in time with a new award, and coming up with options for us to be able to negotiate with the grants management specialist. But a couple other people have stated that, that isn't their understanding with regard to foreign subawards, that they had heard from their program officers that we can no longer collaborate with our existing subrecipient. So my understanding was that you could continue to collaborate with them under an existing award, but once it goes into either a new non-competing year or a renewal period, then we have to wait until after the September 30th date.
That's my understanding too,
Yeah,
Dennis.
that's my understanding also.
When it
and
says
then
the NIH will not issue awards, to me, I read that as issuing a new award. And it also, the language in there is that it's not, it's prospectively, like the notice has the words that the NIH's policy change applies prospectively to all NIH grants and cooperative agreements. So I don't think it's a retroactive thing to existing grants. But again, this came out last week, this came out 10 days ago. So again, uncharted waters. It might be that the program officers you're dealing with don't have a great scope for what the agency is trying to do. Who would have thought of that? An actual government employee not understanding what's coming down from up high. But I think there's probably a lot of confusion. The notice is vaguely worded, and I think the best practices here are to document everything, to document why you're doing what you're doing and to see if you can make it through to September 30th doing what you're doing. But there could be a whole new world with the new policy and new award mechanism for foreign collaborators then as well. But Dennis, right now I do read it the same way you do, but you know, we're all grasping to see what it actually means.
So, so there's a question here that I've been asking, and I have not gotten an answer from anyone. Is there any clarity on why we are expected to terminate foreign subawards now, understanding that they're going to have a new award structure starting in 5 months? Any clarity to that?
I really can't answer that question. I mean, would have made sense if they asked for you to terminate it and then said within 3 days we'll be announcing the new structure instead of 4 or 5 months. I agree with the question, and I don't maybe they want you, to try and wind down some of this yourself so they're not viewed as the bad guy from up high, and they're giving you notice that something new and different is coming down the pike, but I cannot speak to why the NIH is using this timing.
Yeah, and finally, within the guidance, it basically stated that they would be anticipating that they would eventually apply to domestic subcontracts as well. There was a question, once again, having a magic ball would be really nice to say what they're going to be doing. How do we think they're going to be moving to this sub-project approach? Somebody recommended, is it going to be like NSF's collaborative submissions? Or that was in my mindset, but I don't know if there's any clarity as to how they think they're going to move by September 30th.
Yeah, it could very well be where you're just submitting the projects collaboratively in tandem, and I think the word nested under the parent grant, that phrase is interesting because it's saying prohibit the subawards from being nested under the parent grant. Maybe you're having to apply both of them at the same time in tandem in a different way. So hopefully it is something, in my view, hopefully it is something that is just a structural change and not a fundamental change to allowing subawards, especially domestic subawards. We'll see. I mean, I think, we're dealing with a whole new world, and it would not surprise me if the changes are widespread. It would not surprise me if the changes are more structural and procedural. We'll have to see about that. Again, this is all very new, just came out a week ago. And I think what we're hearing mostly is, how do I grapple with my existing awards right now that have a foreign component to them? And I think everyone knows that the government has been full of surprises since post January 20th. And so we'll see.
So just about 2 minutes. So I want to leave, an opportunity for you and Ted to have a minute or so of each to give thoughts on overall future, or what else you may think. Our time has gone by really, really fast. So, so please.
I will take less than 60 seconds. First, I mean, the whole last discussion is a perfect example. Why are they doing this? We have no idea. And most of our clients, everybody, us included, is pulling your hair out because there's the rationale. Why did they make USAID disappear? I have no idea. And we don't know what the idea is. So it's very frustrating. But I do think as a community, we have got to look at legislative solutions, because if there was good legislation providing rights, then you would be able to do you'd know what to do if you're being wronged by the federal government. And right now, it's not clear. And that's I think the ultimate frustration. But anyway, Mindy, yeah.
Yeah, I would just say in this time when things are so not clear, I think as a community, as a research institution, research administrators community, we have to look for where can we get the small wins, right? And I think some of the small wins are internally trying to do what you can to boost morale in your institution, especially in this time where it's very hard to do that. I was on a call with one of my clients and a PI a few weeks ago where we were challenging the termination of the PI's grant, and the PI said on the call, I know this has a very small chance of success, but university administration, I just really want to thank you for hiring legal counsel, for taking me seriously, for showing that you value research and showing that you're going to stand up for PIs like me and my research. And to me, that was, there's a lot of chaos and a lot of crazy out there, but there are things you can do to show that you're pushing back and fighting back. And of course, you have to do what's appropriate for you as an institution in these crazy times. But there are small victories like that I think even in this time of great turbulence, we can all try to hold on to. So on behalf of Ted and myself, I just want to thank everyone from taking the time today. And our emails, I'm going to just scroll to the end of this. Our emails are right here on this last slide. If you want to talk about any of these details and more, any of these issues in more detail, feel free to contact us. We love our relationships with our research administrator and university clients. And thank you to Kathleen and team for having us.
Well,
And
and
so
thank you.
Kathleen popped in, so I'll say, Kathleen, take it away.
Thanks, Dennis. Thank you, Dennis. Thank you, Mindy and Ted. By the way, these three powerhouses will be speaking at the NCURA 67th annual meeting here in Washington, D.C., August 10th through the 13th. So please do stop by the NCURA website and check out the annual meeting program. Thanks to all of you for joining us today, and we look forward to next month's conversation.
Thank you.